As noted earlier, geospatial law cuts across a number of legal domains. These include intellectual property, privacy, issues of data quality and liability, national security, and contracts, in other words, licensing or data sharing agreements. While these issues are not unique to geospatial, the aspects of geospatial described above make them much more complicated. In addition, there are laws and regulations that are unique to geospatial technology or information. For example, the requirements to obtain a license from NOAA in order to operate a commercial remote sensing system, or to obtain a license from a state agency in order to conduct surveying activities. Location privacy refers to the right of individuals to control the collection, use, and sharing of information about their geographic location. In an age where geospatial technology like GPS, smartphones, and the Internet of Things are ubiquitous, concerns about location privacy have become increasingly prominent. These technologies continuously generate vast amounts of location data, often without explicit consent or awareness of the users. The significance of location privacy lies in its potential to affect personal security and autonomy. Location data can reveal sensitive information about an individual's daily routines, places of residence, workplace, social interactions, and even medical appointments. Unauthorized access to this information can lead to stalking, discrimination, or other malicious activities. Additionally, aggregation of location data from various sources can create detailed profiles that may be exploited by advertisers, employers, or government agencies, often without the individual's knowledge or consent. Legal frameworks addressing location privacy vary widely across jurisdictions. In the United States, for example, there is no comprehensive federal law explicitly protecting location privacy, though certain aspects are covered under broader privacy laws and regulations. However, a growing number of states have adopted comprehensive data protection laws which protect precise geolocation information. In addition, the Federal Trade Commission has used its authority to protect consumers to bring enforcement actions against companies that have collected or used precise geolocation information without providing consumers adequate notice or the right to consent. One of the challenges associated with location privacy is defining it. For example, there are several different definitions being used at the state level, and these differ from how the Federal Trade Commission is contemplating location privacy. Another difference is the whole concept of privacy regulations in general, which is based upon the concept of notice and informed consent. Because location information is collected in so many different ways and used in so many different applications, it can be very difficult to provide notice or obtain informed consent. Courts play an important role in location privacy, particularly as it relates to the government use of tracking technology for criminal investigations. This has resulted in an evolution in what constitutes a reasonable expectation of privacy, which could have a profound impact in the future. Another consideration for location privacy is security, both cyber and physical security. The more location information is considered protected or sensitive, the more requirements will be imposed upon organizations to protect it. As a result, it will be increasingly important for organizations to comply with the myriad of cybersecurity requirements being imposed by law, policy, and contract. Liability issues associated with geospatial information arise from the potential risks and legal responsibilities tied to the accuracy, use, and dissemination. As geospatial technologies become more integrated into various sectors, including urban planning, transportation, environmental monitoring, and public safety, the implications of errors or misuse can be significant, leading to legal disputes and financial consequences. One of the primary liability issues concerns the quality of geospatial data. Is the data accurate, precise, complete, or timely for the purpose for which it is being used? Inaccurate or outdated data can lead to faulty decisions, resulting in harm or loss. For example, inaccurate mapping data could misguide emergency responders during a crisis, leading to delays and potentially putting lives at risk. Liability can also arise from the misuse or misinterpretation of geospatial information. Users of geospatial data might lack the necessary expertise to understand its limitations, leading to improper application and subsequent damages. For instance, using geospatial data for land development without considering whether the data is current or complete might result in construction on unstable land, causing structural failures. Providers of geospatial data can be held liable if they fail to communicate the data's limitations clearly. When geospatial information is integrated into products or services, such as navigation systems or environmental monitoring tools, the providers of these products or services can be held liable for any harm caused by their use. This includes not only direct damages, but also consequential damages arising from reliance on the data. Clear disclaimers and robust contractual agreements can help limit liability, but they must be carefully crafted to be enforceable. Intellectual property rights are legal protections granted to creators and inventors to safeguard their original works and innovations from unauthorized use, reproduction, or distribution. These rights are crucial in fostering creativity, innovation, and economic growth by providing inventors and creators with the incentive to develop new products, technologies, and works. Geospatial information frequently involves intellectual property rights, such as maps, satellite images, and spatial databases, which can be protected by copyright or trade secrets. Unauthorized use or distribution of geospatial data can lead to intellectual property disputes. Organizations must ensure that they have the proper licenses and permissions to use and distribute geospatial data to avoid infringement claims. As geospatial information becomes more ubiquitous and valuable, disputes over ownership are likely to increase. However, the enforcement of intellectual property rights presents challenges. In the digital age, the ease of copying and distributing digital content has made copyright infringement widespread. Globalization also complicates the enforcement of intellectual property rights across different jurisdictions with varying legal standards. One primary concern is the potential for geospatial information to reveal sensitive locations and activities. For example, high-resolution satellite imagery can disclose the positioning and movement of military assets, critical infrastructure, and government facilities. The defense and intelligence communities are concerned that this information, if obtained by hostile entities, could be used for espionage, planning attacks, or undermining national defense strategies. However, there is a growing realization that the collection of location information of U.S. citizens also raises national security concerns. For example, one of the concerns expressed about the TikTok app is that it is collecting location information of millions of Americans in real time and sending that information back to China. In addition, there have been several laws and policies in place that restrict foreign governments from gaining access to personal information, including location information, of significant numbers of U.S. individuals. One of the reasons for this concern about location is the integration of geospatial data with other data sources can enhance the capabilities of adversaries. Combining geospatial information with social media data, communication intercepts, and public records can create comprehensive intelligence profiles. This multidimensional insight can compromise operations, personal safety, and national security interests. One of the themes of this class is that geospatial technology cuts across a number of sectors and applications. In the U.S., a number of government agencies have been given authority under law to regulate various aspects of geospatial technology. For example, approvals from NOAA and the Federal Communication Commission are required to operate a commercial remote sensing satellite. Export of certain geospatial technology require approval from the Department of State and/or the Department of Commerce. Operating a drone requires complying with the FAA regulations. Surveyors must get approval from state agencies, and location privacy is protected by both the Federal Trade Commission at the federal level and by a growing number of state agencies. Not surprisingly, the legal and regulatory framework around AI suggests that more government agencies will have authority as both a regulator and a customer. As a result, geospatial organizations must navigate a complex and evolving web of regulatory concerns. Perhaps even more importantly, so must their customers or vendors. Legal agreements, such as contracts and license agreements, play an important role in every technology sector. These include licenses for software, distribution or resale agreements, as well as purchase contracts. However, such agreements play an even larger role in the geospatial sector because of the importance of geospatial information licenses or data sharing agreements. These agreements outline the roles and responsibilities of the parties regarding the geospatial information being licensed. This includes the granting of rights in intellectual property. However, these agreements do more than convey rights in intellectual property. They also allocate risk associated with such matters as privacy, data quality, or compliance with laws. For example, the agreements may include indemnity clauses that protect the data provider from legal claims made by third parties due to the user's actions. Or they may require the parties to comply with applicable law or make representations regarding the data that is being shared. The geospatial ecosystem is inherently global. Geospatial information is collected in or from one country, processed and analyzed in another country, and then sold or used in one or more different countries. Each country has its own government structure, its own values, and its own legal system. These include laws, regulations, and policies associated with legal issues such as privacy, intellectual property rights, liability, and national security. In addition, countries will have their own regulatory requirements enforced by their own government agencies. Some of these requirements can be very different than those in the U.S. Organizations must be aware of these laws and regulations in order to remain compliant. Failure to abide by these requirements can result in fines, loss of licenses, and even imprisonment. Compliance will become even more important and more challenging as more laws and policies are introduced.